afternoon, everybody. Slightly an unusual situation is that, as Josh said, we can't see you, but you can see us. So I'd imagine this is how actors feel when they're on the stage and the lights are shining on them. We know you're there somewhere, hopefully. Anyway, my topic is a rather niche area, and that is, as you can see, is the executors and their removal. Now, the more astute amongst you will realise that I've been quite specific in my title in relation to executors and haven't put personal representatives, certainly to include administrators. In addition, of course, there's also the issue where wills are concerned of trustees. But rest assured, I will be touching on both those issues in this short talk, so you needn't worry. It would appear, unfortunately, due to the pandemic, that, as we all know, the death rate has increased over the last year, and certainly the amount of deaths that are quite sudden has increased. That, in my experience at the moment, has also increased the issue of challenging validity of wills and also potentially under the Inheritance Act. It would appear, therefore, also that now there is a third area that is coming up, and it is mainly from those who are a beneficiary in relation to the estate, and that is in effect not happy with the executors and how they or him or her are conducting themselves. So no doubt in your practice you may be faced with a beneficiary, and I have to say this is more aimed at from the beneficiary's point of view than anybody else, but we'll briefly touch, as I say, on other issues as well. Sit before you and complain that the executor or executors are acting in a way upon which they are not happy. Now, before we start, you no doubt realize that to remove an executor is somewhat of a draconian act when it comes to those that have been appointed by a will. Indeed, as I will refer to later on, these matters are dealt with immediately in the High Court. There is no county court jurisdiction in relation to this, so we can see immediately that the law somewhat takes itself quite seriously in relation to this. But what I would perhaps suggest first of all is that when you speak to those clients, that perhaps you deal with some preliminaries first prior to jumping in with both feet. Normally, beneficiaries are complaining about money and when they're going to get it, or perhaps when they're not getting it. No doubt, of course, you will advise them of the executor's year under Section 44 of the Administration of Estates Act 1925, that they have that year to pay out any bequests and legacies that the will provides for. During that time, of course, no doubt you will advise them that all creditors will have been discharged, and any liabilities the estate has should be discharged. However, of course, it may be a delay before they get that money. So there's that aspect I might suggest in relation to that. In addition, of course, you will also be aware of Part 64 of the Civil Procedure Rules, which allows an application to be made, including a beneficiary, for court direction or orders in relation to administration of an estate. That includes things like maybe estate accounts or otherwise. So instead of using the removal of an executor or somewhat of a sledgehammer to crack a nut, you may think about, of course, looking at Part 64 if it needs to deal with minor issues that can be resolved quite easily. So I would suggest that, as I say, before you do so, you consider the alternatives. However, if those alternatives are either A, been exhausted, or B, just simply aren't available for your client, then it might be that you might have to make an application on their behalf to remove the executors. Where does the power come from? The power is statutory. And you will see on the slide in front of you, it's section 50 of the Administration of Justice Act 1985. That is subsection 1. And you will notice what I've highlighted in bold at the very end, that it is a discretionary remedy. So there is nothing like the Inheritance Act where you can put something into an equation and come out with a result. I'm afraid the discretion is often described as wide and it is unfettered. However, I hear you cry, what type of things should we be looking at? Well, on that slide, I would suggest are the grounds that any court, or the High Court in this case, will be looking at to see whether they're going to exercise that discretion. And that is whether the administration of the estate was being carried out properly, having regard to the welfare of the beneficiaries. And it is the welfare of the beneficiaries, I would suggest, that are at the very heart of this application. And again, followed by another wide ground that the court should consider all relevant circumstances, which may or may not, of course, add to their wide discretion. Now, when a client comes and sees you, they may explain things that it's fairly obvious that an application for removal of an executor will probably be required. Examples may include things such as liabilities not being discharged, monies being misappropriated, and the such like, where, as I say, it's fairly obvious that perhaps an application should be made. However, of course, there is always those grey areas that exist. And one of those, of course, is what normally the courts look at and determine as the breakdown in relationships between the beneficiary and the executor. Now, it isn't necessary, I would suggest, and as the courts have in fact actually held, that it is necessary to establish a wrongdoing or fault on behalf of an executor. Not every mistake, neglect of duty, inaccuracy, or conduct will cause the removal of a representative. So minor errors, I would suggest, does not mean that your application is going to be successful. And that therefore ties back to what I previously said about maybe considering Part 64. But the Court of Appeal have issued useful guidance in some regards in the case that is before you, and it's re Savile's estate. And for those of you of a certain age, yes, that is Jimmy. Anyway, the Court of Appeal said this: direct intervention by the court in the administration of a trust or an estate by the removal of a trustee or personal representative has, for the most part, to be justified by evidence, and we'll come on to that later, that their continuation in office is likely to prove detrimental to the interests of the beneficiaries. So I pause there. That ties into what I previously said, that the beneficiaries are at the very heart of such an application. And the Court of Appeal went on and said this: a lack of confidence or feelings of mistrust are not therefore sufficient in themselves to justify removal, unless the breakdown in relations is likely to jeopardize the proper administration of the trust or the estate. This is something which requires to be objectively demonstrated and considered on a case-by-case basis, having regard to the particular circumstances. And that was by Patton LJ, and if you want the exact paragraph, it's paragraph 83. So there you can see the Court of Appeal saying, hold on a minute, you have to be somewhat circumspect in any application to remove the executors. And have due regard, as I keep saying, to the beneficiaries. But that is not to say, of course, that a breakdown in relationships can simply be pushed aside. It may, of course, be a circumstance that clash of personalities, a breakdown in confidence by the executors and the beneficiaries, it's simply become impossible or difficult to administer the estate, or the estate to be completed by the existing executor. And if that is the case, it ties in again with what I've said. An order for removal will be made, because it's at the beneficiaries that are the very heart of this. The High Court in Kershaw and Micklethwaite, and this is something that you might be worth reading, I would suggest, and Newey J, who gave judgment in this, amplified somewhat that which was stated in Saville, albeit Saville estate was a number of years after this one. But he said that although the administration of the state could have been handled better in some respects, there was no scope for substantial criticism. He found that there was a breakdown in relations between the executors and the beneficiaries, but held it would not prevent or impede substantially the administration of the estate, and was not itself a reason for removing the executors. That would tend to indicate, I would suggest, ladies and gentlemen, that you're going to have to go that stretch further, rather than just simply saying, you know, they've fallen out and they're not really getting on. That case, just to go into the facts a little bit, the applicant had submitted a number of things on behalf of the executors, such as they'd failed to value the estate in respect to property valuations had been too low, failed to keep him informed and provide updates of the estate, failed to correctly identify the extent of the estate. There was a conflict of interests, and there'd been a breakdown in relations. Now, quite clearly, the High Court was having none of it. But as a sort of other aspect to consider, the High Court looked at the size of the estate, which wasn't that great, and the potential cost that would incur in appointing another executor. But also, it took into account that the testator themselves had chosen the executors, and that was a factor that was capable of being relevant. In that case, the High Court held that the testator had given much thought to the appointment of the executors, which weighed against their removal. There was a significant history of the family affairs that the executors were aware of and had been involved in for a number of years. And therefore, in effect, unless circumstances have changed since the executor's appointment, and that normally will apply to those wills that are quite old, the court will take into account, as I've said, why the testator chose those and the fact that he did choose them. Therefore, it's a further hurdle, I would suggest, that one has to overcome, but of course not insurmountable. I'm putting up that case. It was decided by a master in London, and I would suggest that it provides a very good overview of certainly the topic that I am talking about. In that case, the master held the following. This is almost a summary of what I've been talking about. And he said this: the court's power under Section 50 to remove personal representatives is a wide power, as is the court's inherent jurisdiction to remove trustees. He continued, and again, I apologize for repeating this, mere falling out between executors and trustees and beneficiaries is not sufficient, and the executor trustee should not be a hostage to potential mischievous allegations. It is not necessary to find wrongdoing for removal to be ordered. And the core issues, whether there is any detriment to the beneficiaries and the efficient administration of the estate/trust by the person remaining in the office, the overall interests of the beneficiary are key. So there you go, ladies and gentlemen. It rather succinctly puts what I've been talking about for the last few moments. And it's quite a useful case to read, I would suggest. So when that beneficiary is sat before you, they really are front and center in this application. But if it comes to the point whereby you are thinking about making an application, there is, as always in contentious probate, certain procedure that you have to follow. Now, just going back to the case in Schumacher, the judge said this, or the master, should I say, to avoid undue delay in the administration of the estate/trust, while this is not a summary judgment jurisdiction, the dispute should be dealt with promptly. Therefore, ladies and gentlemen, I would suggest having a beneficiary sat in front of you, and then he comes back several months later still talking about the same thing, is not going to find favor with the High Court, given their wide discretion. So in other words, if a decision is taken and advice is given that removal should be undertaken, or application for removal should be undertaken, it's got to be done with all due alacrity. And that is something now that I'm going to reinforce when I talk about procedure. At the top, of course, is a potential pre-action protocol letter. All right. And I would suggest this is undertaken for the following reasons. One is you are about to enter potential contentious litigation. But also, the idea of a removal is that an executor, without stating the obvious, no longer acts in relation to the estate. In other words, following a pre-action protocol letter, you may wish to state in it that you will give them the opportunity to retire. Now, section 50, and I haven't put all of it up in my slides, also can be used in that application to retire. Normally consent orders are signed, submitted to the court, and it's done somewhat on paper, but it prevents potentially a lot of work your end that I'm about to come to that is required, and it is perhaps the easy way to undertake that aspect. However, of course, the question is, how many executors are there? If there are 2 or 3, then a retirement of 1 may not be problematic. If there is 1 executor, then of course a retirement or removal isn't going to leave the estate being not administered, and the court will not have that. I would suggest, therefore, that if retirement is a possibility, and also you are making an application for removal, you line up, so to speak, a replacement. And the civil procedure rules deal with what is required. Pausing there fractionally. Part 57 is what you need to turn your attention to. Okay, all right. And there is a specific part, which is part 57.13, which deals with the removal and substitution of personal representatives. It confirms at 57.132 that all claims in this matter should be brought in the High Court. It also amplifies the fact that every personal representative of the estate needs to be joined as a party. So in other words, if you have multiple executors, they all need to be a party. And of course, potentially, all residual beneficiaries need to be parties. unless normally there are so numerous that in fact actually their written consent can just be obtained without necessarily naming them. Now, I'm not going to go through the practice direction to 57, Part A, paragraphs 13.1 and 13.2, because that lists what the court requires when you submit your application. And it is relatively lengthy, and no doubt you'll be able to read it in your own time. But what an interesting point is, I would suggest, and just to be specific, is at point 13, paragraph 1, subparagraph B, where it states that where a claim is to substitute or remove an executor and is made before a grant of probate has been issued, the original, or if the original is not available, a copy of the will needs to be attached. In other words, what that is saying is, and what that's directed at, is the fact that you do not need to wait for a grant of probate to make an application to remove the executor. And that was held in the case of Goodman and Goodman, which is on your screens. Now, I said right at the very beginning that I said it was aimed at the executors and not personal representatives. And here's where administrators come in at the side. You will be aware, I expect, and know, that an executor's power, so to speak, is derived from the will. It's not really derived from the grant of probate. An administrator, however, his power is granted from letters of administration to him or her. So in other words, if you have a deceased who is intestate, and you have an administrator that hopefully should not be doing anything with the estate until they apply for letters of administration, you're going to have to wait until those letters are granted before you can make an application to remove. All right, so there's that needs to be looked at. Nowhere in the CPR does it say whether a application for removal of an executor should be under Part 7 or Part 8. However, one must read between the lines in this regard, and Practice Direction 57A, paragraph 13.1, subparagraph 2, to be exact, requires the claim form to be accompanied by written evidence containing the grounds of the claim together with other specified information concerning the estate. This, ladies and gentlemen, would indicate, as has been confirmed by that case that is on your screen now, that such claims should be started under Part 8 procedure. So Part 7 does not apply, you do not have full particulars of claim, and we're straight into statements. Therefore, when that client sits before you, that beneficiary, and you've decided or you've taken advice that an application needs to be made, that statement needs to be compiled, because as you will come to see, it is going to be quite a crucial document without stating the obvious. That case went slightly further with regards to procedure, and I can't emphasize enough that it is worth, as I say, looking at. Where, as I say, it confirmed that Part 8 was the appropriate format. And certainly if you're doing it in London on those odd occasions, it can be heard by Chancery Masters rather than High Court judges. But the Master said this: you will need to make an application to them for witnesses to appear and to be cross-examined if that is appropriate. So in other words, there is a default position that such applications will not be a format of cross-examination or otherwise, and will necessarily either be a matter of submissions or undertaken on the papers. And that is why I say, ladies and gentlemen, that when you do your witness statement for that Part 8 application, it really does need to be full and complete, together with, of course, any other witnesses that you wish to put forward. I say that because the master in this case, and I've just noticed a small typo with the English and Wales High Court, that's my error, that the master said the swiftness of resolution was of high importance to avoid ongoing uncertainty for the beneficiaries. So in other words, they're looking to expedite these hearings, one would hope, rather than the usual waiting for months and months and months before it comes before a judge. The justification, said the master in this case, was that the court can determine such cases without making adverse findings of fact about the executors based on cross-examination, because you will remember that there doesn't really need to be a finding of fault on behalf of the executors. It may simply be a breakdown in relationships affecting the distribution of the estate. There doesn't actually have to be specific finger pointing in this regard. And this is drifting slightly into trusts, which I'm going to come on to later, that where there is a claim for potential breach of trust or deficit, that may be important not to make such adverse findings of fact, which may affect future claims of that type if brought later. There was then the wrap-up thing that the judge said, and that was the mode of trial and the level of judge are matters for the court to decide, and they will decide how court resources should be allocated in accordance with the overriding objective. Therefore, ladies and gentlemen, you're going to have to be prepared that this might be A, as I say, a paperwork exercise, or B, that it might simply be in respect of submissions only. You are entering the world of contentious litigation, and therefore costs are in some respect live. But those of you that deal with this issue or contentious probate a lot will also be advising your clients, no doubt, that a trustee or an executor has that protection potentially under Part 46, where they potentially can claim their costs back from the estate rather than being paid by the beneficiary. So if the beneficiary, is unsuccessful, they may be liable for costs personally, or of course, as I say, the executor may be duly protected because of that. So that's something, of course, to bear in mind. Now, I'm going to flip through this because I've just looked at the time and I'm maybe slightly overrunning. I briefly mentioned trustees. And the reason why I do so is, again, those will be aware that sometimes executors and trustees are exactly the same person. And if one removes just the executor part, they still may be a trustee, which may be problematic. So, no doubt, it might have to be a dual application. So they are removed entirely from dealing with the estate. And there are a number of ways of doing this. One is the will or trust document may give an express power. There is the power under Section 36 of the Trustee Act 1925 that you may draw down on. There, of course, is the court's jurisdiction under Section 41 of the Trust Act 1925, or if all else fails, the inherent jurisdiction of the court for removal of trustees. I have to say on that aspect, the principles that I've just enunciated with respect of removal of executors are almost mirrored with regards to removal of trustees. The fourth one, of course, is the compulsory retirement of beneficiaries under Talata. That may or may not apply because it's technical, because it's about retirement of trustees rather than removal. That is also Part 8. So as I say, you can do a dual application.